All right, that's going to be are both sides ready?
Yes, sir.
All right, let's proceed.
Good morning. May it please the court. My name is Anthony Russo. I represent Lung Institute, the appellant in this proceeding. I would reserve, Your Honor, 5 minutes of my time for rebuttal.
You got
The
it.
roadmap for my client's case is, I want to make sure the court understands what it is for this appellate proceeding. We have 2 parts of the case. They correspond to our issues 1 and 3 in our initial brief. Count 1 regards the allegations of the 6th amended complaint of Ms. Rivero and Ms. Mazza that sound in medical negligence that invoke the mandatory provisions of the medical negligence statute, including the pre-suit notice requirements and the statute of limitations in Chapter 95. And their claims, medical malpractice claims, have expired. Therefore, that's another way to say they don't have standing, and therefore their claims must be dismissed. With
Mr. Russo, the count in the complaint that we're talking about was not pled as medical negligence. You'd agree with that, right?
I agree with that, Your Honor.
So to buy into your argument on the various ways that the medical malpractice statute would either destroy standing or create a time bar, what you've briefed, we would have to read the claim that was pled as a medical negligence claim because zebra has stripes. That's
Exactly,
essentially
Your Honor.
your theory, right?
That's correct.
Okay.
And that's the command in several cases that the court is not bound by the labels that that the plaintiff decides to put onto their claim. That you look at the allegations to decide whether or not the medical negligence statute is invoked. I wanted to, and we can go through those, the pleadings. They were pled as medical negligence. We did, I want to show the court that we did rebut those, or we did attack those in the motion, in response to the motion for certification, and that the judge ruled on them, and that issue is properly before this court for review on a de novo basis. And the de novo standard on a standing issue, statute of limitations, comes from the Sosa case. That first issue, from issue 1, is dispositive, Your Honor. If you agree that
it's only dispositive if we somehow shoehorn what they pled as a fiduciary claim into the idea that it's actually medical negligence. And just to keep you lined up with how you've got 20 minutes, so let's use it wisely. I think that's a bridge pretty far to go, and your opponent has taken, among other positions, for purposes of certification, that the damages sought here are not negligence damages. So again, we're not reviewing the merits, but certainly it's his claim, that's how he pled it, and the damages he seeks are fiduciary damages. So
right,
address that.
the medical negligence statute allows for monetary damages. You can get monetary damages under a medical negligence claim, of course. And if the court were to determine this is not a medical negligence claim, then we get to the second part of our action to address your point, Judge Libre, which corresponds with our issue 3, which is the class certification rule. And there we stand on 2 legs. And the first leg is typicality and adequacy are not met by Ms. Rivero and Ms. Mazza because their claims do sound in medical negligence. They are subject to unique defenses because their personal claims are barred by the statute of limitations, the medical one.
That again, it relies on the idea that these are medical negligence claims. I am interested in what you have to say about typicality and adequacy of these plaintiffs, but I'd rather hear it in the context of traditional 1.220 analysis, if you would favor me with that.
And that would be the second leg of our second issue, Your Honor, that the multiplicity of allegations that have been made in the 6th amended complaint overwhelm the typicality and inadequate, well, It's actually more focused on B3 of Rule 1.220, Your Honor. And it's like Rollins versus Butland, where there were a mass of allegations where the plaintiff came in and made 14, I think it was, different allegations of deceptive and unfair conduct by Orkin. And at the hearing on the certification, the judge, as it's identified in the opinion, focused on Orkin's use of the word guaranteed and found that to be deceptive. And when the class was certified and came to this court took apart the complaint and said, no, there's more than that. There are all of these allegations. And in that case, that's when the court, after looking at them, said, because individual questions predominate, the FDUCTA damages claim is unmanageable as a class. And that's
the representations in Rollins were a lot different, and they were overwhelmingly individualized. Here, what the trial judge found is that you have two basic omissions as opposed to representations. And that makes this a little bit different, doesn't it? I mean, this is what wasn't said to ostensibly all of the class members.
Let's go to the damages and what the judge found in his certification order. He said, this is not a medical negligence case, it is a marketing omissions case. And he said, number one, you didn't tell me that there are no human clinical trials. You didn't tell me, Lung Institute, that that the patient coordinators were incentivized. And number three, you didn't tell me it didn't work. And the damages that they're claiming, as my opponent puts in the brief over and over again, is they want all the money back because the treatments don't work, can't work, biologically impossible, it's a sham. So think about it. There is no way, number one, that, well, there are people, the majority of people, we have evidence, the majority of patients did get a benefit from the treatments. So there are people who did not suffer damages, but they were not told, let's take this person, they were not told that the patient coordinators were incentivized, yet they received a benefit from the treatment. They weren't damaged. Why do they get a total refund when they did not suffer damages?
Well, Mr. Russo, let's look at this a different way, and perhaps I'm oversimplifying this. What if we read the claim as you sold snake oil, you knew you were selling snake oil, and you didn't tell anybody you were selling snake oil. It doesn't focus on the end result. It just focuses on the alleged misrepresentation by omission. And the way I see it, there are three defenses that could be raised to that cut across everybody, which is it wasn't snake oil, which I assume would be the first defense. If it was snake oil, we didn't know about it. And the third one would be, well, we told everyone it was snake oil, which I'm sure will not be the defense. So to me, when you look at it through that framework, it's very limited and much more typical for the entire class. So how would you, is that an oversimplification of how to look at it?
No, let's look at it that way, Judge Rothstein. We only go with the first defense. It's not snake oil. And for them to prove damages, it doesn't work. They have to prove it is snake oil. And for them to prove it is snake oil and not a viable, valuable treatment, they have to prove medical negligence. It always comes back to that, Your Honor. They can't get damages unless they can get proof in that the treatments don't work. Now, they've done that with they've alleged such a case. I mean, their Sixth Amendment complaint is filled with this is a sham, it's snake oil, doesn't work, biological impossibility. So they've alleged all those things, but when they get to the hearing on certification, all of a sudden, oh, no, there's only 3 omissions. It's all boiled down to that. But number one and number two, the incentivized patient coordinators and the lack of clinical trials the omissions do not cause the treatment not to work.
I'm sorry to interrupt you, but I think we're about to go way into the land of merits issues, because what we're trying to discern here is whether these two representatives' claims are typical of the other 900 or so unnamed class members. And the claim that's been framed is that these two class members didn't receive these two pieces of information, as a result of which they bought into this treatment that didn't do them any good. And the question for typicality is, and the predominance and superiority issues that I think follow on here is, can these two class members, by proving their claims, prove the claims of the absent class members? And given the simplicity of the omissions, I think what Judge Rothstein-Uickham is driving at is there are not a lot of unique defenses here that are obvious. And to the extent this, just looking down the road at the merits, this almost seems like a quintessential class for certification, because if they prove that it was not snake oil, then you've got your remedy. If they can't prove that it wasn't snake oil, your client benefits by that determination as to the members of the class that don't opt out before the trial or within the opt-out period. So where is the lack of typicality, and why aren't these representatives adequate?
At least two answers to that, Judge LeBrit. And first is that there's a lot more alleged than just these omissions. We're going to trial. If this goes to trial, it goes to trial on the 6th amended complaint, which isn't just 3 omissions. They get to argue everything, which includes it's snake oil in your terminology.
But am I misunderstanding the dismissal? I know that they did it on the eve of the certification hearing, but my understanding of this record is that they pled a myriad of claims, and what they sought certification on ultimately, and what they got certification on, was the single FDUCTA claim. Am I wrong about that?
You're correct, but before the FDUCTA claim and the general allegations, number 1, in the allegations pertaining to class, number 2, and then in the FDUCTA claim itself, just those 3 parts of the 6th amended complaint contain the myriad of allegations. These allegations as to the other elder abuse and RICO, that doesn't matter. We've got them laid out, Your Honor, in our initial brief at page 39. They're summarized there. All of this myriad of allegations are live. They will go to trial. They are medical malpractice allegations. They haven't been dismissed. They're getting the nose under the tent with this omissions. I don't want to demean it by calling it a story, but it's not true. It's not complete. And it's what happened in Rollins versus Butland when they got to the class certification hearing. All of a sudden, everything was just about the guarantee, the single one thing that could be certified. And Judge Wallace, when the court looked at the record, they said, no, this complaint has a myriad of allegations, and we can't. That's what makes it not appropriate, not manageable for and this is not the only time it happens, Judge. We cited the Cohen versus Implants case, and in that was there was a dentist, and he was buying equipment for his to put implants in people's jaws, and it was defective, and he was trying to get other dentists to join him in this class action, and it was denied because all the different dentists had seen different advertising, and the judge says, look, you can't, everybody was induced in different ways. You can't prove commonality. That's, for instance, that's what the problem we have here. And you have in the Stemgenics case, which is the principal case my opponent says that their case is built on. That case was whittled down. The pleadings were whittled down by the trial judge before he ever allowed it to go to trial. And there are 3 Stemgenics orders cited. We have one cited, Judge, the 2017 order of Stemgenics in our initial brief at page 30. And I would commend that to the court's reading because it identifies how the judge said, you've got to scrub all the medical negligence allegations out of your complaint before I'm going to let you proceed with this class action. And that's what happened in PB.
Well, again, I mean, you have the situation where they traveled on, they amended their complaint a number of times. You got a collection of general allegations and class certification allegations, but what the court certified and what they traveled on for certification purposes was the straight up FDUCTA claim. And I'm just cut to the chase. Rollins versus Butland has plenty of interesting information in it, but I don't think it looks as much like your case as, say, for example, the Waste Pro case does. And we have to review this trial judge's findings for an abuse of discretion. So I need you to help me out here on where do we have an abuse of discretion on the typicality and adequacy issues here? And I understand that there's myriad allegations and that you're concerned about having to confront those at trial, but I'm not sure that's part of our review of this certification order.
Mr. Russo, I don't want to interrupt either, but you're at your 5 minutes as you do your answer.
Yes, sir. Judge LeBrit, at page 8 of the judge's order, that's where the errors are. First of all, by saying this is a marketing omissions case. It's not. It's pled as marketing omissions and a multitude of misrepresentations in the FDUPTA count itself. So it's a multitude. That's not what was pled. That's an erroneous statement of law, respectfully to the judge. And then he goes on to say it is not a medical negligence one. That is yet another error reviewed de novo. And then down the page, the judge says the omissions are 1, 2, and 3. And those omissions, number 1 and 2, don't cause the damages, can't cause the damages because they don't have anything to do with the validity of the treatment. It's just what the people were told. And the third omission is it doesn't work. It's a loaded question. You didn't tell us it doesn't work. That's loaded with the presumption that it doesn't work. They can't get to damages. That's a legal error, I would say, Judge. The abuse of discretion comes because we did adduce evidence that these people the patients were induced to come to Lung Institute in a myriad of different ways by all different types of media over a long span of time. How they came, what they were told, their treatment, their experiences were all different. That's all documented in our conclusions, law, findings of fact, in our arguments below. And the judge set those to the side, said, I don't have to look at that. I'm only looking at these 2 omissions. That's
Mr. Russo, you're at 3 minutes. Do you want to save that for rebuttal or you want to keep
Yes,
going?
sir. I will stop.
Okay.
Thank you, sir.
I'll save you the 3 minutes. Mr. Moxon.
Thank you. Good morning. May it please the court, Shay Moxon on behalf of the plaintiffs, Tammy Rivero and Marilyn Mazza. I just want to briefly touch on this medical malpractice issue. Of course, as this court realizes, this is a class certification appeal. It's not an appeal from the denial of their motion for summary judgment. And in addition to our arguments on the merits of that issue that Judge LeBrit pointed out, we have a number of reasons we've argued why this is not reviewable. One of them I just highlight is that this standing theory was never preserved in the trial court. They never argued that.
We've read the brief. Let me ask you a question. Where is the class defined in the order granting certification? Where is the class definition?
Your Honor, I do not know if it's spelled out in the class definition, but it is identified in the motion for class certification, which was granted. And I believe there is an allegation in the 6th amended complaint about what the class would be. And just going from memory, that would be anyone who had undergone a venous, adipose, or bone marrow procedure within 4 years prior to the commencement of the action. So if unless there are any questions on the medical malpractice issue, one other point I'd add, in addition to the argument that Judge LeBrit noted that these simply are not medical malpractice allegations, we also have the point that we are traveling under the separate standard of care provided by FDUPTA, and there's case law that you do not need to comply with the pre-suit requirements when your actions are governed by a separate statutory standard of care.
So what I'd like to hear from you about is your opponent legitimately is concerned that the class certification order is maybe a little bit of an understatement, as I understand his argument, in that you have a bunch of RICO allegations, elder abuse, all these general allegations that apparently remain incorporated to the count on which you got this class certified. And at the end of his argument, your opponent notes that the order on certification says the patient medical histories and other similar concerns asserted by Lung Institute are irrelevant. So are you going to be judicially stopped from trying to prove all of that collateral sort of wallpaper that relates to the medical negligence, what they're calling the medical negligence, and what are a fair amount of peripheral and probably not relevant to the straight up FDUPTA omissions claim that is here? How does that look at trial?
Well, there will be all sorts of opportunities for the trial court to address that. There's going to be arguments about admissibility of evidence and jury instructions. And this gets to a key thing I want to point out that Mr. Russo has not acknowledged here or in his reply brief, but he did somewhat in his initial brief. We explicitly narrowed our theory for class certification to this omission theory at the class certification hearing. We made it very clear to the trial court that we are just seeking certification on this omission theory. And I cited some pages in my answer brief from the record where that happened. Some very clear statements that I didn't cite are at pages 7447 to 48, 10162 to 63. In addition to the pages I did cite 7209 to 10, 72, 17 through 28. Our trial counsel made it clear over and over again that we are, for the purpose of class certification, we are asking the court to certify a class just based on these couple of omissions which were common to the entire class. And even after that, at the motion for summary judgment hearing, which was the third hearing, he reiterated that again and even noted that sometimes as you get closer to trial, you pare down your case, you focus on the evidence that best supports your case and the best theory to go forward on. And so making clear that we're not, not only are we just traveling on these omissions theories, but acknowledging this is a paring down of our theory of liability, in addition to the dismissal of all these counts. And that was at 10162 to 63. And so I had to get that out there. But to answer your question, yes, there are going to be occasions when Lung Institute is going to be able to argue, no, you can't introduce that evidence, or no, we don't think this jury instruction applies because you narrowed down this theory at the class hearing. There might be disagreement. It's something that the trial court is going to have to decide to get ready, as it proceeds to trial. But of course, that's all for the merits.
Well, I mean, part of certification is looking at how the merits trial will play out without determining the merits. And I think that's a legitimate concern that your opponent has raised. I just want to hear it from you, what that really looks like at the trial, given the limited basis that this class is certified on relative to what's in your complaint. So yes. I have another question for you. Having to do with Rollins. Your opponent's been heavily reliant on Rollins, and the majority opinion in Rollins has a fair amount in common with the FDUPTA claims here, the analysis in Rollins as it pertains to the FDUPTA claims in that case. And one read of Rollins is that the majority opinion supports your opponent's argument, and that what you're traveling on is essentially having us accept Judge Whatley's dissent as the guiding principle here. Help me out with that.
Well, to start, Rollins is distinguishable because, first of all, there were 14 different unfair and deceptive practices alleged. It wasn't narrowed down. They were not common to the entire class, and that's the key part there. Here, we narrowed our theory down to omissions that are common to the entire class. We presented testimony that they are, and that has not been challenged by Lung Institute in any of the briefs. Additionally, in Rollins, many of these allegations were non-performance kinds of allegations, such as you didn't inspect my house when you were supposed to, you forged my name on an inspection certificate, you found a termite infestation, but you didn't tell me afterwards, kind of non-performance breach of contract allegations. And based on that, class members or the class representatives were seeking damages to their homes caused by termite infestations. And so there were a whole mess here. There were a number of allegations of different types of unfair practices that did not apply to the whole class. And they were seeking a theory of damages that did not apply to the whole class. And those were the reasons why the court found predominance and typicality lacking. And so Judge Whatley's dissent, as I recall, I think one point he was making was that, well, these damages wouldn't be recoverable anyway. But a key difference here is that we've also focused our theory of damages on what we're really entitled to recover under FDEPTA. And this was also argued at the class certification hearing. We're not seeking any damages for not getting better. Clearly not.
Your class-wide damages, if I understand this record and your arguments, is that assuming you prevail on your claim, the class is entitled on a per capita basis to the return of whatever they paid Lung Institute for the treatment. And is that uniform or is that individual specific?
Well, the measure of damages that we argue for is a uniform method to determine damages. We contend that it's a full refund because under FDEPTA, the damages are the difference between the market price that they would have been able to charge without their deceptive marketing, the difference between that and the amount that they actually charge.
And your theory is that the services were worth nothing, so a full refund is what's forthcoming. And how does that look at trial for the 900 class members?
Well, it's a, quite honestly, I don't know how damage. Well, let me just say that just because individual damage determinations will be necessary.
I know that individual damages determinations doesn't necessarily destroy certifiability, but you still have to have some idea of how to prove it on a class-wide basis. That's one of the manageability considerations. So how are you going to have a statistical model? Are you going to tabulate damages for each of the 900 class members? Where is the efficiency of class certification reached in the calculation of damages for this class?
Well,
because and part of the reason I ask is that it goes to superiority as well. These people presumably paid several $1,000s at least, and each of them could have a fee shift on an individual claim. So that's an argument against superiority here. And I just want to understand, where are we achieving the benefits of class certification when we get to the damages phase of this?
Well, Your Honor, respectfully, Lung Institute has not raised this specific issue, certainly in their appeal, and I don't believe they did at the trial court level either.
Well, I think they challenged superiority on the issue of the small per capita. Certainly, that's a big feature of Rollins. I don't think it's outside of fair game for a review of the certification order, and the damages. The classification of damages is certainly front and center here. It's been talked about throughout your briefs.
Certainly. Well, on the issue of superiority, it's a matter that they're 900 class members, and these are relatively small amounts of damages. If it's full refund, then it's going to be between $6,000 to $12,000 per class member, or perhaps per treatment, and that's certainly too small of an amount to really sustain a personal injury claim with, FDEPTA claim. It's not a personal injury claim. To sustain a a suit with, especially with such complex scientific evidence involved. And, but a point, there are kind of two threads in your question. The other point I was getting at is that the only arguments I've heard from Lung Institute about damages all seem to presume that we are seeking damages for not getting better because treatments didn't work. But again, we're not seeking those damages for that. That's my understanding of every argument they've raised about damages in their initial brief is that some patients claim they got better, some are happy with their treatments, and so damages determinations will vary. Well, that's not true under FDUPTA. This is discussed very well in the Cariolo case, Fitzpatrick, and it's touched on in Davis too. When you have simply a market-based measure of damages, which is an objective standard, and it just looks at whether the deceptive omission affected the amount they are able to charge, then treatment outcomes don't matter. Individual satisfactions with the treatments don't matter. It's simply an issue. It's first is determined under an objective standard. Would these omissions deceive a customer acting reasonably under the circumstances? And then the damages issue is, did this omission affect the amount that they were able to charge? As Cariolo calls it, were they able to charge a price premium because of it? And we maintain, yes, that if they had disclosed this concealed information in their marketing, the market value would have been zero. And so everybody's entitled to a full refund. And case law, number of cases make clear that just because the amount of the refund has to be determined class member by class member, that does not defeat any element of class certification. It's simply, do you have a class-wide method of determining damages? And we have that here. And so have I answered your Honor's questions?
Yes.
Okay. And so I know I've jumped around a bit, but I think I've hit a lot of my main points. So to sum it all up, we have an objective class-wide standard for determining liability based simply on a couple of omissions that are common to the entire class. We have an objective standard for determining damages where individual outcomes, individual treatment, factors for seeking treatment don't matter. And that's touched on this Stemgenics case. The Ninth Circuit opinion mentions that. Another case involving deceptive marketing of so-called stem cell treatments. So the elements, predominance is satisfied, typicality is satisfied because the plaintiffs are asserting the same legal interest and the same injury. And I've touched on superiority. If the court has any more questions about that, I would address that some more. And of course, the medical malpractice issue we maintain is not reviewable and fails on the merits. Unless the court has any more questions, we ask you to affirm.
All right, thank you. Mr. Russo, you've got 3 minutes remaining for rebuttal.
Thank you, Your Honor. Interestingly, my opponent said there'll be so much complex scientific evidence. Complex scientific evidence shows that they intend to prove in total conformance with their pleaded allegations that this treatment doesn't work. That makes it a medical malpractice claim. When you assert that you've been treated by a sham product, that's medical malpractice. And that's what this all revolves around. It's just been admitted here. It was argued in opposition to the certification motion, and we've identified in our brief where under typicality and adequacy, the medical malpractice, the exclusivity provisions apply to their Rivera and Maza's claims. And I would urge the court, if there's any confusion about what is alleged, to go through the Sixth Amendment complaint, through the general allegations, through the class allegations, which is the next section, and then their first count, which is the FDUPTA count, and stop there. And you will find 21 allegations of multifarious bad acts under FDUPTA. We've identified those at record 9933 below, where we took out and identified, quoted those to the trial judge. We've identified them in categories, 5 different categories of types of bad actions under FDUCA in our initial brief at page 9. All of this comes from the FDUCA count, and to come now and say, oh, it's just these 3 omissions, that's not what is pled. A trial is guided by.
We've got this order, and it certifies on this claim on these omissions, and now you've got your opponent telling us that that's what he thinks he's going to try. Maybe you're going to have some scuffles about the scope of evidence on that, but
Judge, if the court thinks this is not medical malpractice and they can proceed on a FDUCA claim, the case should go back to let them plead it, because that's not what is pleaded. And that was what the decision was by this court in Rollins versus Butland, to dismiss the class as unmanageable as pled and allow them to go back and try to plead a case that fits through the eye of the needle of FDUCA. And now that third omission, Judge, please pay attention to the third so-called omission, which is you didn't tell us it doesn't work. That is not an omission. That is an accusation. That has built in it the assumption your procedure doesn't work. That's where the complex scientific evidence comes in. That's where they put the people on the stand, their pulmonologists and their researchers, and say, no, there's no way that this treatment could work. And then that's when
Mr. Russo, I don't want to interrupt, but you've used up your 3 minutes. Did you want to take another 10 seconds to say adios?
Yes, thank you, Your Honors. We ask the court to dismiss we ask the court to dismiss. Thank you.
All right, thank you, gentlemen, both. That concludes the oral argument today, and we're going to be in recess.